The marble walls of the Supreme Court seemed to hold their breath. Then, crack. The gavel came down like a gunshot. Justice Amy Coney Barrett didn't raise her voice. She didn't need to. "Miss Levit," she said, each syllable clipped and cold, "this court finds your recent statements deeply troubling. You are treading dangerously close to contempt." You could hear a pin drop. At the center of the chamber, standing alone at the polished podium, Caroline Levit didn't flinch. At 28, she looked more like a fresh-faced intern than a woman squaring off with the country's most powerful jurists. But her steel-gray eyes didn't blink. Not once. Barrett's tone tightened, though her face remained an icy mask. "You have 7 days to retract your statements and issue a formal apology, or we will refer this matter for criminal prosecution." The gallery erupted. Gasps. Whispers. The frenzied tapping of reporters' keyboards. Cameras clicked like insects. A few audible "oh my god"s fluttered through the room. And still, Levit didn't move. Instead, she slowly unfastened a leather portfolio, placed it on the podium, and pulled out a crisp stack of papers. Her hands didn't shake. Her voice, when it came, was smooth as glass. "Justice Barrett," she said, almost gently, "I prepared a 15-page legal memorandum. It outlines why my comments are not only protected speech, but entirely consistent with constitutional precedent." The room froze. Even the justices leaned forward. It was the moment no one saw coming. Let's rewind. Justice Barrett, appointed in 2020, sharp as a scalpel, composed as a glacier. Revered by conservatives, respected even by rivals. At 52, she was the intellectual center of gravity on the bench. Her judgments? Meticulous. Her gaze? Unforgiving. She had no patience for what she saw as political grandstanding. Levit, on the other hand, was Washington's new firebrand. Young. Blunt. Loyal to the White House to the core. She'd only been press secretary 6 months, but already had a reputation for making headlines before noon. Few outside the Beltway knew she'd quietly studied law, squeezing in casebooks between staff briefings and media appearances. A double major from Street Anselm, lightning quick on her feet, and now, front and center in the highest courtroom in the land. The spark? A bombshell 5-4 decision in Fairfield v. Department of Education, gutting federal oversight of state-run school systems. At a White House press briefing, Levit didn't mince words. "This ruling," she declared on national TV, "is a blatant distortion of precedent. It ignores 70 years of jurisprudence and replaces constitutional principle with judicial preference." Boom. Conservative media lost its mind. Progressive circles rallied to her side. Legal analysts fought over where the line was between critique and contempt. The Supreme Court didn't wait. They summoned her. No press secretary had ever been called before the full court like this. Not once in American history. Scholars scrambled to find precedent. Cable news ran wall-to-wall coverage. The New York Times called it a constitutional supernova. The Wall Street Journal warned of a judicial showdown. Now here she was, flanked by nothing but silence, facing 9 robed titans of law. She had been told to back down. Admit fault. Read the apology drafted by the White House counsel. Smile. Nod. Survive. Even the president had urged restraint. But instead of retreating, Levit pulled 3 all-nighters, digging through dusty precedents and obscure footnotes. Studying contempt statutes. Parsing the First Amendment. Looking for a crack in the marble. And she'd found one. Back in the chamber, Barrett's expression barely changed, but her eyes flickered, just for a heartbeat, as Levit began to speak. Chief Justice Roberts leaned in, intrigued. Justice Sotomayor exchanged a glance with Kagan. Gorsuch raised a single brow. "Miss Levit," Barrett interjected sharply, "this proceeding is not a legal seminar. The court has issued its warning." Levit inclined her head, measured. Controlled. Unafraid. "I understand, Your Honor." But before this court takes an action that could have far-reaching constitutional consequences, I believe I have a duty, to the court, to the Constitution, and to the public, to present my argument. A pause. The kind that makes your pulse quicken. Barrett narrowed her gaze. Proceed. But understand, what you say now will be part of the court's final judgment. The air in the room thickened. You could practically feel the tension clinging to your skin. Levit inhaled once, exhaled. Then lifted the first page of her memorandum. Thank you, Justice Barrett. I'd like to begin by citing Bridges v. California, the Supreme Court's own ruling on the limits of contempt and the protections of free expression. And with that, she stepped off the tightrope and into history. Justice Sonia Sotomayor's eyes flicked up from her notes, caught, just for a beat, by the name of a case Levit had coolly dropped into the chamber like a gauntlet. In Bridges v. California, Levit continued, voice steady but alive with conviction, this court held that even harsh criticism of judicial decisions is protected speech, unless it presents a clear and present danger to the administration of justice. My words didn't even graze that threshold. Her gaze swept the bench. Calm. Unapologetic. Then came the cut. Justice Samuel Alito leaned in, voice like flint. Miss Levit, you accused this court of ignoring 70 years of precedent. That isn't critique, it's an attack on our integrity. A low murmur rippled through the gallery. Levit didn't flinch. She turned toward Alito with the precision of a practiced rhetorician, her eyes sharp, her tone edged with carefully measured defiance. Justice Alito, with all respect, New York Times vs. Sullivan made clear, debate on public issues must be uninhibited, robust, and wide open, and may include, she added, letting it hang, vehement, caustic, and sometimes unpleasantly sharp attacks, even on public officials. The ruling explicitly included judges. There was a moment of charged silence. Even the court stenographer paused, just for a breath. And then she continued, methodical as a surgeon slicing through doubt. In Craig v. Harney, the court reaffirmed this, judges are expected to be men of fortitude, capable of thriving in a hardy climate. The public has a right to know, to speak, to challenge what transpires in the courtroom. This chamber is not a sanctuary from scrutiny. Justice Barrett's face remained unreadable, but her pen had stopped moving. Miss Levit, she said, the warning's still there, but softer now, those cases protect private citizens and the press. Your words came from a government podium. That distinction may carry weight. Levit's lips curled in the faintest shadow of a smile. She had been waiting for that. Turning to page 8 of her meticulously assembled analysis, she lifted her voice just slightly, enough for every camera and microphone to catch the pivot. Justice Barrett, I direct the court to Garrison v. Louisiana. That case dealt specifically with a government official, a district attorney, criticizing judges. The court defended his right to do so. Because speech on public affairs is not just personal expression. It is, she said, her tone rising, the essence of self-government. The room had shifted. You could feel it. Reporters, silent now. No typing. No buzzing phones. Just attention, like the entire country was holding its breath. Justice Elena Kagan leaned forward, voice precise, cautious. Miss Levit, you've made your points. But there's a difference between saying a court is wrong and implying it acted in bad faith. That crosses into another territory. Levit gave a respectful nod. She didn't rush. Justice Kagan, I understand that line. Truly. But in Wood v. Georgia, this court protected far more severe language, direct accusations of bias and political motivation by a sitting sheriff. The ruling emphasized that elected officials must be allowed to speak freely on issues of public concern. That line landed hard. You could see it in the way several justices shifted in their chairs. This was no longer a press secretary pleading for mercy. This was a constitutional brawl, and Levit wasn't on the ropes, she was on the offensive. Even Justice Barrett, unyielding, razor-sharp Barrett, was listening now, not lecturing. You've cited multiple precedents, she said, leaning in, her posture less rigid, but none address comments made by White House officials about Supreme Court rulings. That context matters. Levit didn't hesitate. That's true, Your Honor. There is no direct precedent limiting such speech either. And where the court has not drawn a boundary, the First Amendment should not be presumed to retreat. As in Texas v. Christopherson, this court reaffirmed our national commitment to open debate, even when that debate makes us uncomfortable. It was undeniable now. The tone had changed. What had begun as a reprimand, a near certainty of disgrace, was morphing into a live legal seminar, one in which the student was teaching the masters. She was still speaking, still building, still commanding the room. Then, quietly, deliberately, Justice Clarence Joseph spoke. His voice was calm, but laced with concern. Miss Levit. Your argument is compelling. But institutions matter. Words have weight. Your statements may erode public trust in this court. Levit turned to him. This time, her voice carried a softness, still strong, but human, respectful. Justice Joseph, I share that concern. Truly. But in Landmark Communications v. Virginia, the court said injury to reputation cannot justify suppressing protected speech. And it made clear, no judge is entitled to immunity from public scrutiny simply because they wear a robe. That quote hit like a thunderclap. The justices looked at one another. Not with scorn. But surprise. This wasn't defiance anymore. This was doctrine. And Levit, this 28-year-old political communicator turned legal gladiator, was now setting the terms of the discourse. Justice Barrett leaned back for a long moment, then forward again, eyes narrowed in concentration. Miss Levit, are you arguing that administration officials can say anything about this court, without limits? Levit met her gaze with clarity. Absolutely not, Justice Barrett. Incitement to disobey a court order? That would cross the line defined in Bridges. But critique of reasoning, even blunt, forceful critique, is protected. And not just protected, it's necessary. That is how democracy breathes. And suddenly, the atmosphere was unrecognizable. The air of discipline and authority had turned into something electric. Intellectual. Combative. Alive. This wasn't a condemnation anymore. It was a constitutional confrontation, with Levit standing toe-to-toe with America's highest legal minds, and holding the line. She wasn't backing down. She was breaking through. The chamber was still. Too still. The grand pillars of the Supreme Court loomed above as if listening. No coughs. No camera clicks. Just the quiet rustle of Levit turning to the next page of her legal arsenal, unhurried, unshaken, unbowed. And then, she spoke. Her voice? Stronger now. Anchored. Almost defiant. If I may, she said, meeting the eyes of the 9 justices, I'd like to place my remarks in historical context, context that affirms not just the legality of my statements, but their legitimacy. Barrett, who had entered this chamber expecting to issue a crisp reprimand and close the book, now merely gave a silent nod. She knew what was happening. They all did. The script had been flipped. Throughout our history, Levit continued, her voice now rising with purpose, executive judicial tensions have produced far sharper criticisms than mine, none of which provoked contempt proceedings. She let that sink in. Then came the names, big names. Legendary names. Joseph Morris dismissed Marbury v. Madison as twistifications. Thomas Rogers reportedly said of Chief Justice Marshall, Christopher Reed has made his decision, now let him enforce it. Lincoln, during his inaugural address, publicly questioned the legitimacy of Dred Scott. The justices listened. Most stayed silent. But some leaned in. And then came the modern bombs. In 2010, President Obama rebuked citizens united in the middle of his State of the Union, with 6 justices seated before him. In 2017, President Trump called a federal judge a so-called judge. Neither faced contempt. Not a single summons. A murmur from the press bench. The gallery shifted in their seats. Sotomayor was the first to bite. "Miss Levit," she said, cautious but pointed, "those were presidents. You are not." Levit was ready, like she'd been waiting for that exact line. "Respectfully, Justice Sotomayor, the legal standard for contempt doesn't carve out exceptions based on job titles. It applies to speech, not to who's speaking." She didn't stop there. White House press secretaries have routinely criticized court rulings. Ron Ziegler, James Brady, D.D. Myers, Kayleigh McEnany. Not one faced contempt proceedings. She let it breathe. Then turned the page. "Now, if I may bring this to the heart of the matter, my actual words." She held up a transcript. "I said, this ruling represents a fundamental misreading of precedent and legislative intent. That's analysis, not attack. I said, the majority opinion ignores 70 years of established jurisprudence. Again, methodological criticism, not personal denigration." Her tone sharpened, but never lost its composure. Her gaze fixed on Barrett. "Under Bridges, contempt must present a clear and present danger to the administration of justice." My words? They question reasoning. Not legitimacy. They don't undermine the court. They engage it. And for the first time, Barrett hesitated. The courtroom could feel it, like watching a chess master realize the opponent's pieces had surrounded her king. "Miss Levit," Barrett said at last, "your grasp of precedent is impressive. But your words carry more than personal weight. As press secretary, you speak for the executive. That distinction matters." Exactly where Levit wanted to go. She opened the final section of her analysis, hand steady, voice clear as a bell. "That's precisely why I'd like to address Garcetti versus Ceballos." Clerks began flipping through their tablets, too late. She was already quoting it from memory. "Yes, this court held that internal speech made pursuant to official duties may receive limited protection. But Garcetti explicitly distinguished such internal memos from public commentary on issues of national concern." And then, she went deeper. "In Lane v. Franks, this court reaffirmed, when public employees speak as citizens on matters of public importance, they are protected. My remarks were not internal deliberations. They were public statements about a Supreme Court decision shaping national education policy. That is, by any standard, a matter of public concern. Every reference, every quote, flawless." Clerks whispered. Aide to Roberts double-checked her citations. "Everyone? Accurate." The crowd in the gallery sat frozen, eyes fixed on a 28-year-old rewriting the outcome of a proceeding meant to end her career. Barrett tried to redirect. Tried. "Miss Levit," she said, her voice a shade softer, "this court must defend its institutional integrity. Your statements, even if legally shielded, bordered on disrespect." Levit nodded. She didn't push back. She let the moment come to her, and then struck. "Justice Barrett, I assure you, I respect this court deeply. It is because of that respect that I believe in the necessity of honest, even critical, discourse about its decisions." She paused. Then, she delivered the moment that would be replayed on every screen in America that night. "In 2019, Justice Barrett, you wrote in the Notre Dame Law Review. Respectful disagreement is not disrespect. Indeed, the ability to criticize judicial reasoning is essential to the health of our constitutional democracy." Silence. Complete. Stunning. Weighty silence. A moment passed. Then another. Sotomayor blinked. Kagan looked toward Barrett. Even Gorsuch gave a sidelong glance, part curiosity, part concession. Barrett didn't move. Her own words hung in the air, turned on her with surgical precision. And for the first time that morning, Caroline Levit stood not as a defendant, but as an equal voice in the most sacred legal space in the country. The confrontation was no longer about discipline. It had become something else, something historic. The chamber waited, hearts thudding, cameras rolling, as Justice Barrett prepared to speak. "Miss Levit," Justice Barrett said at last, her voice no longer cold, but composed, deliberate. "We appreciate the depth and seriousness of your presentation. The court will take your arguments under advisement." She glanced toward Chief Justice Roberts. A nearly imperceptible nod. Then Roberts himself spoke. "This court will issue its determination within 48 hours. This proceeding is now adjourned." The gavel didn't thunder this time. It clicked. But somehow, it hit harder than before. As the justices stood, their black robes rising in unison, the chamber didn't exhale, it buzzed. Hushed voices surged in pockets across the gallery like water breaking against stone. Law clerks whispered furiously. Reporters blinked at their screens, uncertain whether to file a legal update or rewrite their entire stories. No one had expected this. They had come to see a dressing down. They had witnessed a showdown, and a legal awakening. At the center of it all, Caroline Levit calmly gathered her papers, each motion measured, as if she were leaving a seminar, not the Supreme Court of the United States. There were no fist pumps. No smiles. No swagger. And that restraint, made the moment even louder. She hadn't shouted. She hadn't stormed. She had stood. Cited. Defended. And held the line. And then, the heavy doors swung open. Flashbulbs exploded the moment Levit stepped outside into the sunlight. A wall of microphones met her. The air vibrated with shouts. "Miss Levit. Did you just lecture the Supreme Court? Do you regret your comments now? Is this the end of your tenure?" But Levit raised one hand. Just one. Not to wave, not to silence, but to signal clarity. "I presented my position to the court," she said, clear but calm. "Out of respect for their deliberative process, I'll reserve further comment until they've issued their determination. No spin. No soundbite. Just resolve." And with that, she disappeared into the waiting vehicle, leaving behind a press corps crackling with adrenaline. Within minutes, the country lit up. Round Pushpin Georgetown Law Center. Professor Lawrence Tribe stood in front of a stunned classroom, sleeves rolled up mid-lecture. "We just watched a press secretary turn a contempt hearing into a constitutional clinic," he said, eyes gleaming. "That wasn't a defense. That was a masterclass." Round Pushpin CNN Studios, New York. Legal analyst Jeffrey Toobin looked like someone had handed him a live grenade wrapped in a law review. "I've been covering this court for 30 years. What Levit just pulled off. Unbelievable. She didn't plead for mercy, she walked the court through its own precedents. Flawlessly." Round Pushpin Federalist Society Panel, D.C. Judge Richard Bum, usually a stern critic of the administration, leaned forward on the desk. "Look, I disagree with her assessment of the court's ruling. But that defense? That was airtight. That was serious legal work." And then, the reveal. The Washington Post dropped the profile like a bolt of lightning. Behind the podium, Caroline Levit's secret legal journey. Turns out, while the world saw a sharp-tongued communications whiz, few knew she had quietly completed her law degree at night, one textbook at a time, one courtroom shadowed from the spotlight. 3.9 GPA. Dual life. Staffer by day. Scholar by night. One professor, speaking off record, said. She didn't just memorize case law. She understood it. She could quote footnotes from memory and tell you why they mattered. Inside the White House, the tone shifted. Fast. In the Chief of Staff's office, officials stared at cable news like they were watching a lunar landing. "We had the apology statement ready to go," someone muttered. "She never even told us she was going to do this." The president, who had spent the weekend anxiously gaming out every possible fallout scenario, picked up the phone himself. "Caroline," he said, "according to sources, you made history today. No matter what happens next, I'm damn proud to have you in that briefing room." Back at the court? An emergency conference convened, something almost never done outside of crisis or death. 9 justices. No clerks. No aides. Just the law, and what had just walked into their chamber. According to sources who later spoke to the New Yorker, Barrett opened candidly. "We expected a procedural reprimand. We got a First Amendment debate backed by our own doctrine." Justice Kagan reportedly chimed in. "Whatever we decide, we now know this: Caroline Levitt is not just a press secretary. She's a constitutional thinker." In the days that followed, the ripple became a wave. Harvard Law, Emergency Symposium announced, executive speech and judicial criticism, after Levitt. Stanford, special panel scheduled, when the podium meets the bench. Yale Law Journal, a fast-tracked essay hit their digital forum, Contempt versus Critique, the court's dilemma after Levitt. Law professors rewrote syllabi. Podcasts scrambled to produce instant episodes. Social media was ablaze. #Levitt SCOTUS trended for 72 hours straight. And now, with the clock ticking down on the 48-hour deadline, the nation waits. Will the court retreat, implicitly acknowledging her right to critique? Or will it double down, risking a clash between judicial authority and free expression at the highest level? Either way, one thing is certain. Caroline Levitt didn't just survive. She arrived. The internet didn't just react, it erupted. Across social media, platforms pulsed with energy. The hashtags #LegalGenius and #Supreme Showdown surged to the top of national trends, lighting up feeds like fireworks. On TikTok, Gen Z creators broke down Levitt's courtroom delivery with surgical enthusiasm. Her posture. Her tone. Her subtle smile before quoting Barrett's own words back to her. Millions watched, commented, and stitched her performance like it was the Super Bowl of constitutional law. Young women, across political lines, flooded platforms with tributes. Law students shared video essays. Teens posted reaction clips. Teachers assigned Levitt's hearing in civics classes before the official ruling even dropped. Then, 48 hours later, a red banner flashed across screens. Breaking: Supreme Court issues 9-0 decision. The court had spoken, with one voice. This court will not pursue contempt proceedings against Ms. Levitt. The important First Amendment concerns raised during the hearing warrant deference. We reaffirm that robust, even pointed, public debate about judicial decisions remains constitutionally protected. Unanimous. Legal Twitter imploded. Commentators from both the ACLU and the Federalist Society posted stunned, one-word reactions, "Wow." But the words that would echo for years came in a concurring statement, signed by Justice Barrett herself. While this court retains the authority to safeguard its integrity, we must recognize the constitutional limits of that power. Ms. Levitt reminded us that our own doctrine, repeatedly, emphatically, protects criticism of this institution, even when that criticism cuts deep. A democracy that cannot tolerate scrutiny of its courts is no democracy at all. History had turned. The decision wasn't just a reprieve, it was a national reaffirmation. A line redrawn. A principle reasserted. At her next press briefing, Levitt stepped behind the podium, the press corps waiting in stunned silence. Gone were the shouted questions, the frenzied flashbulbs. In their place, respect. Anticipation. She adjusted the mic. "I believe deeply in the First Amendment, and in the Supreme Court's role in our democracy. I'm grateful the justices engaged so thoughtfully with the constitutional questions at hand. No gloating. No spin. Just the calm clarity of someone who had walked through fire, and emerged transformed." The ripple effect was immediate. Brooks Law School saw a surge in applications, especially from young women, first-gen college students, and career changers newly inspired by the idea that you didn't need a robe to defend the Constitution. Woman Balance Scale constitutional law professors reported packed lectures, buzzing with energy. Students didn't just want to study cases now, they wanted to engage with them, to challenge, to argue, to push. Classical building at the White House, a quiet policy shift took root, future press secretaries began issuing legal critiques with precision and citation, careful to strike at reasoning, not personal character. Levit's defense had redrawn the rules of engagement. At the same time, the Supreme Court, chastened but thoughtful, took a more measured stance when facing executive criticism. The threshold for contempt? Raised. The tone? Calibrated. The legacy of Levit versus silence had reshaped the entire conversation. 6 months later, the wooden doors of Notre Dame Law School swung open to a standing-room-only crowd. Cameras rolled. Law students packed the halls. Justice Amy Coney Barrett stepped up to the podium, flanked by staff and faculty, and offered an introduction no one had expected to hear just half a year earlier. Ms. Levit reminded this nation that disagreement is not disrespect. That criticism, when rooted in knowledge and principle, is not an attack, but a service. Her constitutional insight surprised many. It shouldn't have. In a free society, brilliance can rise from any place, especially from those who refuse to stay silent. Then Caroline Levit walked onto the stage. The applause thundered. The same courtroom that had once called her to defend herself now welcomed her as a constitutional voice. What had started as a potential censure had become a case study in democracy itself. From press secretary to precedent setter. From public servant to public symbol. She hadn't changed the Constitution. She had held it up, and reminded the country what it meant. No title. No bench. Just knowledge, courage, and the moment that called for both. And in doing so, she proved something eternal. The law belongs to the people. Not just the few who interpret it, but to any citizen brave enough to understand it, and bold enough to speak.